Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today I wanted to go over the lawsuit process, or rather the process of a case from beginning to end, and maybe talk about some of the important times in the process, in the timeline. When are the critical times that you could do something, and when are the critical times for the attorney to do their magic, right, and to make the case worth more? So usually a case starts with an injury victim calling an attorney and choosing an attorney. And that's actually a critical time right then, because you want to make sure that you choose the right lawyer. You want to choose a lawyer who has a track record of success, that has obtained verdicts and settlements in the amounts that you as a client want to obtain in your own case. Because if they've done it before, then it's likely they're going to be able to do it again. Whereas if someone has never gotten a $1 million verdict, then the chances of them getting that first million with your case are pretty much slim to none, because it could be that that lawyer is not a trial lawyer. They just don't go to court. So it's unlikely the insurance company is just going to call them up one day and say, you know what, I know you never go to court. I know you've never won a verdict before a jury, but just take our $1 million today. The chances of that happening is pretty much slim to none. So it's really critical that as a client, you choose somebody who's a trial attorney, who has that track record of success that you're looking for in your case, and not necessarily go with the billboard lawyers, right? Because a lot of the billboard lawyers just putting up big billboards and they want to attract you, but they're not usually the lawyers that go to court. They don't have that track record of success. They're just trying to run law as a business and make money for themselves. And that can end up screwing you, the injury victim. So once you hire a lawyer, the lawyer should really get to work on your case and do a full investigation. So that could be going to the scene, if it's a car crash, taking photos, getting images on Google Maps, right? Hiring an expert if necessary, depending on the type of case, really leaving no stone unturned and doing a full investigation and understanding everything. And a lot of the best lawyers, what they do is they do everything early. Like they'll hire the experts, whether it's an engineer, safety expert, depending on the type of case, right? It could be an accident reconstruction expert, trucking expert if it's a truck crash, but they'll hire all the experts early. They'll spend the money. They're not afraid to spend the money. Because some lawyers, what they'll say is, oh, do I really need an expert? Maybe I'll just go without an expert. And then later they've taken a deposition of a defendant, but they don't have an expert. And because of that, they haven't asked the right question. And now because they haven't asked the right question that an expert would tell them to ask, now the whole case is in jeopardy of being lost, right? So it's critical to do that full investigation and leave no stone unturned in the beginning. Once you've done the investigation, the client is also getting medical care. And the other critical thing for the attorney to do is to help coordinate this medical care, right? If you see the client's going, let's say, to a physical therapy office, and that physical therapy office just keeps doing chiropractic adjustments or, massages, but they're not doing anything else, you want to steer the client to maybe like a specialist, right? And then the specialist will evaluate them, get them the right testing they need, like an MRI, magnetic resonance imaging. That'll get a diagnosis. What's their problem? Instead of just like cracking their back over and over again like a chiropractor, you get them an actual diagnosis. Hey, here's the diagnosis you have. The MRI says you have a herniated disc. And then you see a specialist for that, like a pain management doctor. And then you might need an injection or other treatments, possibly even surgery. Then now you have doctors that can come to court and testify in court as like neurological experts, orthopedic experts. That's what you want for a legal case. You don't necessarily just want the physical therapy. So once you have that, the client's treating, at that point, depending on the type of case it is, if it's going to be a small case, let's say a 25 policy car crash case, you could just pick up the phone and settle it, right? If they're done treating, the client's done treating, you could settle it, get $25,000, $20,000, whatever it is. If it's a little bit more, because the policy is big, let's say it's like, 10 million policy, and then the client has serious life-changing injuries, they're going to need injections, they're going to need surgery, then obviously you want to file the lawsuit. Once you file the lawsuit, They have 30 days to then answer and appear. You get a preliminary conference with the judge after that. You give them, in New York, we give them a bill of particulars, basically answering their questions, like what's the negligence, here are the injuries, answering all their questions. And then, at the preliminary conference, the judge will say, okay, well now here's your schedule for the case. It's a scheduling order. Here's when depositions will be done. And then you basically follow that schedule. Now, of course, sometimes they get adjourned a little bit, like you think depositions are going to be on this date. For whatever reason in New York, a lot of the times, I think the defendants like this, they always confirm the depositions the day before. So if you have a court order for depositions, you could confirm them a month before, and you have to obviously, before a deposition, a good plaintiff's lawyer is going to meet with their clients 3 times or 5 times and really prepare the client so the client is fully prepared for that deposition. But if you don't know if the deposition is going to go or not because the other side won't confirm until the day before, that's actually a disadvantage for the plaintiff's attorney. But what you have to do is prepare them anyway. And if it gets adjourned, then you prepare them again. But you don't have to prepare them as many times because they've already been prepared at the next date. And I try to always adjourn them for a short date, like 2 weeks. But oftentimes the defendants are going to say, oh, our calendar is booked until May. We're going to want to adjourn it for like 5 months. So you have to be careful with that. So depositions, and then at the same time, there's also document discovery. So the defendants are going to ask you, meaning the plaintiff, for medical records, authorizations, and then you could ask them for documents. And you want to get the critical documents from them that you're going to use to prove your case. And then once depositions are done of the plaintiff and of the defendants, you file a note of issue and you certify the case as trial ready. Now it goes on the trial calendar. And at this time, you're going to have offers for like mediations, settlement conferences, pretrial conferences. These are all chances to settle the case. And at this point, you already know everything, right? Like how the accident happened, what's the injury, what do the defendants know, and you have most of your experts, you have your exchanges of documents. So at this point, when you're on the trial calendar, that's usually when most cases settle. And if it's not going to settle, then you have to just prepare it for trial, do your final subpoenas, all your notices. And then you also want to exchange like witnesses if you haven't done so already. Probably it's better to do it before depositions to have the client start thinking about, well, who are people from my life that could help tell my story, right? Like friends, coworkers, whoever it is, circle of friends. And then each person tells like a little bit of a story about how this incident has changed the injury victim's life. So you have all that, you give all that out, and then basically you can try a settlement opportunity letter. You could say, look, let's settle the case for $1 million. Here's all the evidence. If you need anything else, let me know. I'll give you whatever you need because I want this to be a true opportunity to resolve this case for, let's say, $1 million as an example. But if it doesn't get resolved, that's fine. And you give them a timeline like 30 days. If they need more time, sure, 60 days, 90 days, whatever you need. But like if it doesn't resolve in this opportunity that I'm giving you, well then I'm going to go to trial. But guess what? At trial, it's not going to be $1 million anymore. It's going to be $5 million. So, you make your choices and you put them in the corner. And that usually works to get them either to pay you a substantial amount. Like I've gotten a lot of cases where they've said in the beginning, they were like, no, I'm not going to pay $1 million. But then later, maybe a few weeks after, they say, okay, I'm going to pay the $1 million, because they see that if they don't pay the $1 million now, then later it might be $3 million or $5 million or more than that, right? So that's always a better way of negotiating. For whatever reason, I think also the insurance companies direct this. They're the ones who created this. The typical way to negotiate is just to call up and say, I want like $1 million. And they say, oh, are you crazy? That's so much money. Why don't you come down? Why don't you ask me for 200? Okay, how about 200? Okay, well, yeah, that's more reasonable. I have 20 for you. And then we'll see what they do. And then now 800 is gone, right? You're asking for 200, they have 20, and they want to get you down maybe to like 60 or whatever. They want to bring you down into their world, into their small world, where they could settle the case even for 60. But guess what? If it's $1 million policy, they just saved themselves $940,000, right? And they're playing with the little crumbs, whereas the main piece of the case, the lion's share, is gone, and they've saved that already. And then they don't really care anymore at that point, whether it's 60 or 50 or 70. That's at that point it's done. They've won and you've lost. So you want to make sure that you negotiate on your terms and negotiate from a position of strength. But that's basically like the critical time. And I think the critical time when lawyers have to review these cases is during discovery, because First of all, you have to prepare your client. The client has to do a good job at depositions. There's so many pitfalls, so many things that a client could say that could ruin a case, both on liability as well as damages. So that's critical. The other critical time is when the plaintiff's attorney is questioning the defendant. First of all, one of the tricks they pull is they give you a defendant who's a know-nothing witness. Like if it's a simple case, like a case of maintenance, let's say, where there was an unsafe condition, you want the porter or the super or the person who deals with this condition on a daily basis. But what they do is they produce some guy who's like sitting in some corporate tower on the 38th floor looking out, on other skyscrapers. He doesn't know anything about this condition. He's never been to this building. They maybe own 50 buildings, and he's gonna talk to you about, I don't know what, right? He's a know-nothing witness. And a lot of lawyers will just depose that, whoever they produce, and then stop and say, okay, well, I did a deposition. Let me put it on the trial calendar. Great. You're on the trial calendar. Sure, the case is moving along. You could tell the client, hey, I filed a note of issue, which is good in terms of time, but you haven't deposed the right person, so you don't have any way of proving liability. You've deposed some corporate exec in a case where you should have deposed the super, and now you're in danger of losing the case. So the critical thing is to make sure you find out who's actually has knowledge. And oftentimes what you could do is you could depose former employees, people that used to work there that left, and they'll tell you the truth as opposed to towing the company line and just telling you what the defendant wants to say. So it's really critical to uncover these kind of like frames, to question the right people. Another technique that you could use that a lot of lawyers don't is saying, look, these are the issues in the case, these are the topics, and now you give me a corporate representative for an organization, whether it's a trucking company, whether it's a big box store like Target, Costco, Walmart. And then when I question that corporate representative, he's not speaking or she's not speaking as an individual, but rather they're giving me the official company position as to whatever I want to find out about, like safety or, whatever the issues are in the case, right? So that becomes very powerful because then that has legal effect and then you can use that at trial. Whereas a lot of lawyers, for whatever reason, don't do that, and then that makes the case weaker. So there's a lot of different things you can do, and it always depends on the type of case it is and how you want to, what levers you want to pull and how you want to make the case stronger. But that's basically the procedure in terms of how a case goes. So I think the critical steps are in the beginning, the investigation, definitely depositions and discovery. And then of course, the most critical time is right around trial, where you're either going to try the case and you have to come in with a position of strength and confidence and you're going to win a big amount. Or if they pay you enough, you could also settle the case at that point. Okay, I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. Please like and subscribe to our channel, and all the best, everyone. Bye-bye.